All right, everybody, let's see if this can work. We had to switch from Zoom last week to go to meeting or go to webinar for a lot of different reasons, but I'm not real sure why the password wasn't sent out with the invites. But what we're going to do is we're going to record this and it will be shared. So those of you who didn't make it on, we definitely will get this out immediately. I'm going to start back over and say how excited I am about having today's guest. We've gone through this already and just realized that nobody was listening, so we're going to do it all over again. I'm going to start with introducing the two guests on our panel. Really excited about these guys. The first one I'm going to just read. As you guys know, I'm not very good at doing, but I want to get everything in his bio correctly here. Elliot Golding, member of Squire Patton Boggs Data Privacy and Cybersecurity Practice and Healthcare Industry Group Leadership Team. Elliot has also been selected as an honoree in the Global Data Review's inaugural 40 Under 40 list, representing the best of the data law bar around the world. Elliot, thank you for joining us the second time.
Thanks very much for having me.
That went not nearly as good as the first one, but hey, we'll take it. Now, the second one, I will tell you that I'm certainly really excited about being here. Some of you have already seen this guy speak from the stage, heard his broadcast, known his posts that he does out there. And so Eric Troutman, he's one of the country's prominent class action defense lawyers and is nationally recognized in the Telephone Consumer Protection Act litigation compliance team. He's also served as lead defense counsel in more than 100 national TCPA class actions and has litigated nearly 1,000 individual TCPA cases in his role as National Strategic Litigation Counsel for major banks and finance companies. And more importantly, as I alluded to earlier, yeah, if we can mute until we join. Hey, this is how things are being done today, but let me explain something. Eric, you are also czar of TCPAworld.com. We've known you. Obviously, you're there sporting some of your swag, as you always do. Welcome and thank you. I think we're going to iron out these kinks on this one fairly soon. Thank you for joining.
Happy to be here, Rob. Anything for the council.
I will hold you to that later down the road. Hey, to quickly get into this, since we're a few minutes already past the top of the hour and I want to get this thing rocking and rolling. Elliot, since, I haven't really had a lot of time talking with you, but that's not saying that privacy isn't one of the more important things that we deal with at the council. I'm super excited to have you join and talk about the things that are going on. One of the things that I believe that I'd like to hear maybe at the beginning is just maybe a recap of where we are. Let's talk about COVID right out of the gate, because there may be some specific things that we need to worry about. We hear about it every day. And let me know a little bit about where the world of privacy is from your viewpoint.
Yeah, it's challenging times because, for the most part, there hasn't been really any waivers of the privacy and cybersecurity rules that apply. I mean, if you're subject to HIPAA, there's a very small waiver of certain types of information sharing, but right now people are trying to get information about their employees, share that, make sure people aren't getting sick, or if they are, they're staying out, and everyone's shifting to remote work, which raises a lot more security issues. The thing that, bottom line is the same rules really do apply, and I'd say most companies are probably at more risk right now than they were a few weeks ago. So it really needs to continue to stay front and center for companies during this time.
So, I guess, and thank you for that. I guess as we dive a little bit deeper, the world of privacy has been on fire, and it's amazing to me because I remember backing up a couple of years ago when the GDPR stuff really started hitting, and how we started seeing the privacy statements across the bottom of every website change. And, I think from what my experience was, most people probably felt like just putting that privacy statement or updating their privacy statement did about all they needed to do for GDPR. Right. And so, now fast forward, we've had CCPA and some other things, but tell me, let's back up to that GDPR moment and where we may have progressed from that to where we are.
Yeah, I mean, I think when GDPR came out, everyone had a mad dash up to that deadline, and I think some people thought, well, once the deadline hits, we'll take a breather. But for the most part, a lot of companies weren't fully compliant by that date. They got maybe some of their external facing stuff up, but people had to continue working on it. I think we saw the same thing happen with the CCPA, the California Consumer Privacy Act, where we had a January 1st deadline this year. And unlike the GDPR, where people had 2 years to get ready, people dealing with the CCPA had way less time. Plus, the law was amended 3 months before it went into effect, and we didn't even get regulations that were in draft form a month before. So it was a little bit crazy. And I'm a risk-based kind of guy, and was trying to help clients say, well, what do we do? The regulations aren't even final. So what a lot of companies ended up doing was they got done what they could, particularly the external-facing things. And most companies have spent, the past 4 months since the enforcement deadline or the effective deadline, doing more the internal things that had to support that program. Because as you said, getting up a privacy notice is great. It's a key part of the law, but it's hardly all that the law requires. You have to back it up.
Yeah, I think that's exactly what the message should have been, or is ongoing, at least from what my angle is and what I continually hear from all of the attorneys that we've talked to about this. I'm going to get back to you on some of the specifics. I'm going to break down some of what you just covered, because in what you said, I think there's a whole lot of nuance in between the lines there, and I want to come back to that. But because I know Eric's chomping at the bits over there to join as well and get started on this, Eric. And I also know that Eric's going to help us on the privacy side come back and find all of those things as it relates to call centers and COVID and privacy. But Eric, look, give me a bit of a state of the union of where we are. Let me know what's going on, and give me just a brief update. I follow your website. We post everything. So obviously there's a lot of cases that are still going that have been really big, but give me your 50,000 foot here.
Yeah, so this is going to be one of the few, maybe the only webinar ever where, I'm not the most important panelist, is the truth. Because right now, as everyone speeds to remote, trying to move everyone off into, outside of the physical call center environment into a virtual call center environment, data and privacy become more important than they've ever been. And data protection it had been this juggernaut. It had been so important. There'd been so much focused on it. And then all of a sudden, boom, you got 72 hours to move your operations remotely. And data security, data integrity, it fell in terms of your priorities. It fell to second or third or fourth or fifth on the list. And so the future is going to be remote. And that makes folks that are operating call centers and operating facilities that make outreach, it makes them more important than they've ever been before. But in the short term, we have to all recognize that the reality that we're living in a hacker paradise, where there's going to be so many data breaches coming out of this conversion. And so folks like Elliot and the powerful Squire team that handles privacy and breach litigation is just critical today. But if you're operating a call center, you have to understand that there's that risk element that's built into moving remotely. And from a TCPA perspective, what's this going to lead to ultimately? Those of you that are lead buyers and lead sellers, it's going to lead to a huge amount of additional consumer data that ends up on the black market. And that consumer data is, in all likelihood, going to end up being pitched, whether or not it's ultimately bought or sold. It's going to be pitched to lead aggregators and performance marketers. And what exactly is going to be done with that data? And is that going to translate into leads that you as a lead buyer, you as a valid caller, might be inadvertently, unknowingly calling, creating litigation risk for yourself? It's tough to say. But today, what I do know is as we have moved into a remote environment, our data and the integrity of that data becomes more important than ever before. And that includes leads. And that includes making sure, therefore, that you have analytics around how your call volumes are performing, assuming you're still allowed to make phone calls. We'll talk about that in a second. And knowing whether or not certain leads that you're buying, certain pockets of leads, are resulting in a unusually high number of DNCs, let's say, that might indicate there's some level of fraudulent activity going on out there. We've got to be hyper vigilant to that right now, because the regulators are not going to give us a pass. And I've got a couple war stories to share with you already, where the FTC and the FCC are coming down real hard on people right now. So something we have to take seriously.
Yeah, I mean, that's serious tone of you. I like hearing that, but I also want to point out that you went almost 2.5 minutes without saying the TCP or the letters TCPA early on. That's how important this privacy thing is over there to you, Elliot. Just hearing Elliot, hearing what Eric had to say, help me understand, is there something in what he said? Is there some truth to that? Are you monitoring and tracking? Obviously, when he starts using words like FCC and FTC out there and all the things that we know, and we're not even talking about the state of California right now. What's your response to that?
Yeah, I couldn't agree more. I think that, just by the nature of things, there may be a lull in enforcement for some period of time, but regulators have long memories. So even if they don't have the resources today to actively start investigations, they're going to come back to it. And do you want to be the company that was trying to do your best, maybe not perfect, or do you want to be seen as the company that really didn't try that hard to keep complying with the rules and keep data safe? Yeah, because they're going to have to pick their cases. And I always tell clients, you don't want to be the easy set of facts.
I think that's super important. In fact, we had, I know Jonathan Pompin from Venable has sent me numerous emails talking about our behavior during these times and, making sure that we don't take these opportunities of disruption and where we feel like everybody else is disrupted. Everything we do is recordable, first of all, and recorded. Secondly, I would imagine, as you guys have alluded to, everybody's got us in their peripheral vision anyway right now. And so I think our behavior as lead generators and performance marketers certainly needs to be as narrow and as straight as we've ever seen, because I think at this point in time, people are looking for the bad actors, looking for those people who are taking advantage. Eric, you talked about fraudulent activity. I want to get back to that in a little bit, because I believe that fuels a lot of what we see in the call center that might be a TCPA violation. And then for you, Elliot, a CCPA violation as it relates to, storing and working on data that isn't accurate. Eric, I want to come back to you because there's been a lot of activity that I know specifically for you and I have talked about on the stage many, many times. And I want to back up to something that happened last year before we actually get into TCPA. I want to talk about something. The first time I met you was on a stage with our friends over at DNC.com at their conference. And I remember you, the very first things out of it, if you don't pay attention to TraceStack, and I had no idea what that was at the time, and I thought I was pretty well connected to things, but we had something happen on TraceStack last year. What was that?
Yeah, so the Trace Act became law, and it's a little bit of a watered down version. When you heard me talking at DNC.com's Great Florida Summit back in December of 2018, there was a different version of Trace that was being circulated that had significant jail time built in for violators, and after that, there was another bill called the Stopping Bad Robocalls Act that was working its way through the House. Ultimately, the Trace Act got a little bit watered down, which is a good thing, but it ultimately did pass. And the downside to Trace, in my view, is that it does still create a working group of the FTC, the CFPB, the Department of Homeland Security, a number of different organizations, basically every agency with an enforcement arm, to get together and to determine how you can do one thing: increase the number of criminal prosecutions under the TCPA using an existing criminal provision built into the Telecommunications Act of 1931. So this is, it's not a great development. Immediately spinning out of Trace, you're seeing a number of DOJ actions currently against VoIP providers and carriers. You're also seeing a number of citations being issued by the U.S. Telecom Group, as well as the FTC and the FCC. So regulation in this space is going through the roof. Enforcement by regulators is going through the roof. And with COVID right now, these folks are absolutely cracking down on anything that can be perceived as anti-consumer in this space. The notion being, of course, that consumers need to be protected more than ever during a crisis. And notwithstanding what Elliot was saying about resources maybe being stretched at this time, we're seeing a lot of enforcement activity. So it looks like the regulators are using their resources to crack down, certainly on scams, but on high volume callers generally. And we're seeing a lot of traffic that's being caught up in spam filters, being caught up by the carriers who, as everyone now knows, has the ability to put you and enroll their network users into default call blocking apparatus. And those things are being used to catch even COVID emergency messages, which is a real problem.
I failed to mention, because I always have to, and I wrote it down before this, when we mentioned traced, one of the things from the stage that I always do, I bring up something to tell me what traced actually means. And so I just want to say that that acronym stands for Telephone Robocall Abuse Criminal Enforcement Act. And one of the things that I point out from the stage is that C&E makes a really big deal in what this is. Unlike TCPA, that C&E, criminal enforcement, as you mentioned, Department of Justice getting involved in some of these things, I think that's a big game changer for some of these things. And we've seen some cases over the past 6-12 months where decision makers within companies are actually being held accountable for their decisions, and in some cases criminally.
You're right. So the TCPA is unusual amongst most federal statutes, and hopefully everyone listening to this webinar already knows this, but if you are a officer, a compliance officer, or a CEO, or even just a person in a call center, you can be held personally liable under the TCPA for damages of $500 to $1,500 per call if the call that you're making on behalf of your company, or if your company, at your direction, or in a way that you participated in, is violating the TCPA. You personally can be sued, and you personally can lose your personal fortune as a result of that conduct. So TCPA compliance is extremely important. And then when you layer in, as you were just talking about, the potential for criminal enforcement. Now, understand, there's been very few criminal prosecutions under the TCPA to date. But these things are ramping up. In fact, again, the DOJ just filed the first couple of criminal prosecutions this year that we've seen, and they're bringing them under an aiding and abetting theory, which is classically, the bad guys, the real bad guys, are overseas outside of the jurisdiction of the DOJ, but they're finding the people here in America that, in that case, were the gateway network providers. And they're going to say, hey, look, you knew what you were doing. You knew you were enabling these scammers to come into the states, and they came in through your networks, and we're going to hold you liable criminally, perhaps, put you perhaps in jail for allowing those bad actors to come over your networks. That's incredible. Now, obviously, the folks listening to this webinar, most of them are not carriers, although we might have a couple of carriers tuning in. But the analogy is obviously that if you are making phone calls that you know to be illegal, or you are allowing, or let's say you're a lead provider and you know that some of your lead product isn't what it appears to be. Maybe you've fallen to the dark side and you've allowed some of this dark web information to make it into and get populated and peppered into your lead information. There is a judgment day coming now, and it's not just civil liability. It's not just a class action. You could end up with those fancy silver bracelets on your wrist, and you could wind up in jail. And this is a real thing that's happening right now.
Well, you put that in perspective now that I think we should all be paying attention if we weren't before. Because we had a little bit of a technical glitch at the beginning, I do want to point out that one of the housekeeping items that I do normally point out, there is in your control panel for GoToWebinar a questions box. Please, if you have questions for these two panelists, ask them. If we can get to them through the duration of this webinar, we certainly will. They both have said that they're going to take the time either during and or after to get these questions answered. So please use that. They're paying attention to it. The reason why I teed up the Traced Act, though, was so that I could come back to you, Elliot, and talk about CCPA. We mentioned it very briefly at a 50,000 foot early on, but one of the things that I've heard, because prior to January 1st, when CCPA was going to go in, there were a lot of people, and even on the stage with you and I, Eric, there was an attorney saying, hey, look, January 1, we're going to start seeing lawsuits. And we haven't really seen that. And so with what Eric was saying with Traced, where we have not seen the bulk of what we probably will say, can you give us a real good overview of CCPA, where it came from, where we are today, and why we haven't probably seen something as of January 1?
Sure. So for people who aren't familiar with the history, the CCPA started off as a ballot initiative in California. And California's a bit unique in the way it does those things, but they were polling really high. It was going to pass the ballot. And one of the consequences of that is it would remove the ability of the legislature to legislate the topic if it went through. It could only be amended through further ballot initiatives. So at the very last second, the sponsors of the ballot agreed to pull it in exchange for the legislature passing a law. And they literally did this in a day or two. So the result was a very poorly worded statute that was going to be further implemented through regulations. They sort of compromised on the availability of a private cause of action. And that's part of why I think we're sort of seeing a little bit of a drag in actual litigation occurring, because it wasn't as broad as they originally designed it. Right now, the CCPA has a private cause of action, but only for data breaches. Now, plaintiffs have started bringing class actions that not only assert the claim under the CCPA, but are also going to try more creative venues or avenues like the California Unfair Competition Law, like the Private Attorney General's Act, things like that. So we have seen a handful of those cases come in, and I expect there to be more after that, but that's perhaps why there's a bit of a lull. It wasn't just a broad private right of action. So with that, the downside is if you do have a breach, it's now statutory damages. And for anyone familiar with breach litigation, will know that a lot of the times that there's a breach, there's a lawsuit, but no one can show they were actually injured, and it gets dismissed. With the new statutory damages, you don't need to show injury. So I do think there's going to be a huge uptick, specifically around breach. We'll have to see what happens for claims of just other violations of the CCPA, like the obligation to give a really robust privacy disclosure notice, the requirements to honor all the individual rights, delete or to opt out of the sale of information, or to register as a data broker. There are a lot of elements to it, but we'll have to see how those develop. If you want to know more about kind of the history, though, where we are right now is we have the third iteration of regulations that the Attorney General has issued. And my gut is that although they're not final, they're not going to change much more at this point. There is a July 1st enforcement date that is upcoming that the AG has said will not be pushed back despite COVID, and has said many times that all activity starting on January 1st is within the scope of enforcement. So I think a lot of people have this mistaken notion that it doesn't really go into effect until July 1st, which is not true, or that as long as they're compliant by July 1st, they'll be fine, which also is not true. So companies really need to be dealing with it now and do the best they can to get compliant with it.
Do you have, Rick, are you chomping at the bits over there to say anything? I'm sure, no?
Well, I mean, look, hopefully what folks are taking away from what Elliot just said is the private right of action that exists right now in California that gives you standing and that affords statutory damages is around data breach. And hopefully you're drawing a thread here in terms of a theme, because when we first started we talked about moving to a remote environment. We talked about the risk that creates, where you've got a bunch of frontline workers, maybe call center workers that now have remote systems. Maybe they have a laptop, God forbid they have a thumb drive that possesses consumer information or access to that information, hopefully with credentials. But as Elliot will tell you, it doesn't take a whole lot to convince somebody to turn over some information, or if they lose that information, and you've got that private right of action baked in a way that you never had before. So this is a perfect storm. You've got, for the first time ever, a very clear private right of action, a very clear damage remedy, a very clear standing articulation in the statute, and you've got an environment where a bunch of folks that aren't used to protecting data are now in possession of it, remotely, outside of the presence of the sort of controls that information security teams would normally have in place. I predict massive upticks in data breach litigation. And again, from a TCPA perspective, the more data breaches there are, the more fraudulent data there is out there, the more likely that leads might not be what they seem. And so that, again, makes it critical that those of you operating call centers are paying very close attention to what your analytics look like. And if you start seeing a big spike in do not call requests from a certain data source, you've got to pull that. You've got to know who you're dealing with. You have to make sure that these lead sources you're buying from are legitimate companies. And if you see something unusual, you've got to flag it and you've got to get an explanation from those guys. You cannot let yourself become victimized by somebody else's misdoing. It's just, unfortunately, the stakes are too high.
Eric, I'm sorry, Elliot, if you were to put on, your crystal ball hat, which Eric is not afraid to ever do for me when I ask him, to look into the future, because we had attorneys sitting on the stage predicting January 1, do you see something like, do you have a feeling for when we're going to start seeing this? Obviously that 6-month period built into, here we are rapidly approaching June, which I would imagine is that 6 months. Are we going, and COVID's going to play into this. I obviously understand that as well. How do you feel, just in your gut, how do you feel this thing is going to start seeing its light of day?
Well, there's two components, right? There's the litigation side, and we probably already have, 5 or 10 out there. There was a really, really big one filed just a few days ago related to a certain telecom provider. I think it's going to grow a lot more come July 1st, particularly once we start seeing attorney general investigation and enforcement work. I think you're bound to see follow-on litigation the same way it works with other industries, like the government investigates antitrust or the government investigates something. They do a lot of the work for you, and then you can have that follow-on litigation. So I think people might be waiting to test the waters, particularly plaintiffs' attorneys who have to obviously invest a lot in getting that lawsuit going until there's some case law, but I think it's going to be exponential. Not to draw a parallel here to COVID, but once it starts going, I think it's going to speed up very quickly towards the end of this year. Now, the Attorney General regulatory, I think for some people might be the scarier part of it, right? This was a law that was designed at many of the practices this industry, engages in, giving people proper notice of where their data came from, how it's being used, letting people opt out of the sale of it. It's very difficult to comply with those things if you don't really know where you got the data from, to Eric's point, and don't have really good visibility into the data that you have. So I think that if the AG is going to focus on a few particular parts of CCPA, the types of practices that a lot of folks listening to this engage in are probably top of the list in terms of priority.
I love when I can plug one of our board members or members of the council. And so I keep hearing ad fraud. I keep hearing ad or fraud, being part of this ecosystem over here on the privacy side and on the TCPA side. So, Rich Kahn and Honora, I'm going to throw a shout out to you right now, because you've been preaching to me about fraud and the traffic that fraud generates and how it is feeding into these potential lawsuits, both on the privacy CCPA and privacy breach side of it, and for you, Eric, the TCPA side. So anytime you're going to talk about fraud, I think we all listen. I know that Rich has been preaching from day one. I'd like to jump back over to you, because this is more of my sweet spot of where I've been following this for years. And, we've talked about Trace, but I'd like for you to just take a moment and back up to 2015 for me. And there's a reason why I'm saying 2015. I think it was 2015, where the FCC talked about something, and that started a whole barrel roll. I'd like you to give me just kind of that little history lesson for me for a little bit, and kind of end up where we are today with what you're seeing.
So I think you're referring to July 10, 2015, the omnibus ruling by the FCC. Obviously, that was the red letter date when the commission issued its broadest articulation of the reach of the TCPA by interpreting the automated telephone dialing system, ATDS definition, to include essentially any software-enabled dialing device. That is any device with the capacity to, in the future, be converted into an auto dialer without ever actually identifying what the functionalities of an auto dialer are. The DC Circuit Court of Appeal in March of 2018, of course, set aside some element of that ruling, and maybe the earlier rulings from 2003 and 2008, in which the FCC had first started expanding the ATDS definition. It looked, following the Marks case in September of 2018, that the courts were going to align that the DC Circuit actually did set aside all of the FCC's ATDS work. But as we just saw 2 days ago in Duran versus LaBoom Disco, the Second Circuit Court of Appeal disagrees and believes that the earlier 03 and 08 rulings are still binding law. So without kind of cutting to the chase here, there was a long period of uncertainty following the ACA International decision from the DC Circuit Court of Appeal, setting aside something, but not entirely what was set aside. No one really knows, even now. But now we have a massive, incredibly stark difference of opinion, some would say a split of authority between the Second and the Ninth Circuit on the one hand, which interprets the TCPA's ATDS definition very broadly to include any device that can call from a list of numbers automatically. And on the other hand, the statutory definition, that is to say what the statute actually says, which requires the use of a random or sequential number generator to trip the statutory coverage. And that's being followed by the Seventh Circuit and the 11th Circuit, and maybe by the Third Circuit. It's a little bit unclear what the Dominguez case actually held. But you've got a very, very stark conflict here, and it is just kind of, unfortunately, business as usual in TCPA world, because anyone that follows TCPAworld.com will tell you, and I'm sure that's everybody listening, it's a mess. It's been a mess continuously since 2008. Patchwork rulings have been coming down from district courts that refuse to allow the FCC to issue binding guidance. And then, of course, when the FCC did issue guidance, it flew in the face of reasoned decision-making, as the DC Circuit Court of Appeal found. And now nobody wants to wait for the FCC to redo their work, even though the remand has been pending for nearly 2 years now. And so we just live in a world where a phone call is either legal or illegal, not depending on where it was made, not depending on who made it, not depending on who answers the phone, but depending solely on what jurisdiction you got sued in. It's remarkable, it's unconstitutional in my view, but that's the world we live in.
We're going to get to a few of those comments that you just made and break those down a little bit. I do appreciate that. Elliot, I'm going to bounce back to you. It's like a tennis match here. You know, CCPA, as you and I had talked about on our practice run here, is just one thing, right? And although COVID has slowed down a lot of other things, I do remember being on the stage in January, and there were no fewer than 14 other states out there running strong into the wind of developing their own privacy law. Help me understand, because I know that the industry is wanting a federal mandate. Yeah. What are we looking at here? I mean, are we looking at more of the state, or and let's try to parse the COVID, pause out of that, and let's talk about what are we expecting, or what are you thinking is going on?
I think if you ask 100 people, you can get 100 different answers to that question. My gut, someone who's followed this for a long time, is that federal legislation, at least federal legislation that's preemptive of state laws, is not going to happen. Part of that is just the current environment. It's not top of mind as it once was. But two is, we're talking about a law in California that has the largest contingent of delegates in the House. And Pelosi, and the last I saw, went on record as saying she's not going to push through a law that preempts her own state's attempt to regulate privacy. I mean, they've been trying for 15 years, 10 years to pass a national data breach law, because right now we have different laws in every state and territory that make it a complete mess to do notification. It takes something that would be expensive to begin with, and when you have to slice and dice it 50 plus territories, 56, 57 ways, it dramatically increases the cost of dealing with it. And they haven't been able to reach agreement on that. And that's a lot simpler to figure out what data, how many days do you get to do the notification? Do you have to give credit monitoring? It's not that much variation, or the number of topics. Privacy is way different. How broad and scope do you want to define personal information? California defined it to mean literally everything, right? An IP address, a cookie ID, all those things are probably personal information. And And then what rights do you give people? You know, is it the full suite of GDPR style rights? Is it no rights to access, to delete, to have control over data? You know, I think California kind of struck a middle ground there. They didn't go quite as far as GDPR in some ways, but they went a lot farther in other ways. So just having the federal government decide all the various pieces of what goes into a good privacy law, I just don't see it happening. And if it does, it won't be preemptive. Is my guess. As for the states right now, you know, not to come back to COVID, but you know, there were 14, 15 states with pending legislation. You know, Washington was probably the best candidate to pass a law, and they could not reach agreement at the very last second over a private cause of action. So it died in session. It's just a matter of when, not if, though. New York and Virginia were probably the other ones that were the scariest, because in many ways they went a lot farther than the CCPA. I think right now the legislative agenda at the state level is probably not going to be privacy for the next few months. It's going to be COVID. But look at this as a slight reprieve, perhaps, for a few months, and using this as an opportunity to get your house in order before these laws go into effect. And I do think there's going to be a lot more private causes of action in them. So starting to do that work now, you only just get ahead.
I think that you mentioned, we talked about the cause of action and the ability to sue and get judgments, but that was one of the things I remember, Eric. We were at a conference last year, and we were talking about CPA in particular, and you're like, well, the private right isn't there. It's not going to have a lot of teeth, and we talked a little bit about that. Elliot, you mentioned something to me on one of the practice sessions that we had. That's not totally true about the entirety of it, because in data breaches, that's there, right, in California?
Yeah. Well, in the CCPA, there is a private cause of action for data breaches. There's some very specific things that need to be satisfied before you can probably bring that cause of action. But I think we're going to see a lot of people be very creative and try to bring cause of action for violations of the entire statute, nothing to do with data breach. And right now we're seeing that happen. It's just a matter of letting the courts go through it. Even if a court decides the CCPA didn't convey a private cause of action for the rest, it's going to be extremely expensive to defend those lawsuits. And it's just a matter of time before someone comes up with something creative enough to get through. So that's just my sense on it.
Help me before we get out of this thing. I do want to talk about some of the things that we could be doing today as companies to fend some of that off. So I want to get back to that. Eric, I'm going to bounce back to you. There are a lot of things, and I'm listening to some of the questions that are coming in. And one of the questions that was specifically asked was ringless voicemail. I do want to just throw it out there because we talk about it. It always is a question that comes from the audience. First of all, ringless voicemail is not a call, right? It's not a call, right?
Ringless voicemail is a call.
Oh, it is.
Okay. It's definitely a call. There's no question about that. So ringless voicemail, unfortunately, guys, it's just not going well. So there were 3 cases. Everyone might remember from last year. Saunders was from about a year and a half ago now, as a kind of the first case in the space. And initially, defendants were making this terrible argument. I don't know why they were making this argument. I think it was handed to them originally by somebody that did a white paper or something. That was a good argument. It's just ridiculous that voicemail's Title III information service. It's not a Title II telecommunication service, and so somehow the CCPA doesn't apply. I never even understood the argument. It's like to me, it's like the most red herring kind of non sequitur thing. But that was the argument that was being advanced, and the courts were looking at it and saying, I don't get it, rejected. And so there was 3 cases right in a row where court said, no, it's a call, and your Title III argument makes no sense. Then VOAPs came into the mix, and the founder, David King, great guy. He was on our podcast, the Unprecedented podcast on tcpaworld.com. David comes on and he explains, hey, look, fine, it's a call, maybe, but it's a call made over a business class landline to a third-party service provider, not to a specific phone number using the cell phone network. Therefore, it's not going to trip the B3 requirement that you make the call to a number assigned to a wireless carrier. Fantastic argument. I think that's a winner. frankly. However, that was kind of presented late in the game, and there's already a body of law finding that ringless voicemail are, in fact, calls. And unfortunately, just last week, there was a ruling out of Florida in a case that said, nope, I'm going to reject your argument. I don't care that the statute requires the call to be made to a number assigned to a wireless carrier, and you're not doing that. Nonetheless, I'm going to look at the language of the statute and the intent of Congress in these previous cases. I'm going to find that somehow this product is still subject to the TCPA, and the use of a ringless voicemail without express consent is going to trigger statutory coverage. And that's exactly what the holding was.
Yeah, I think that that's really, at the end of the day, it's a call, falls under TCPA, you should have consent, bottom line, and you'll be safe, right? There was a question, and I think that this wraps in a lot of things, and we've got about 14 minutes, and I want to be aware of the time that you guys have given us today, but I want to get into something that's very, very interesting and very important, I think, third-party lead verification. And one of the things that specifically a question came in, if, let's say, for instance, you use a Jornaya or an active prospect, right? You have third-party lead verification. You have your privacy statements. You have all the stuff right on the front end. But when it comes in, it says, the person says to plaintiff, "It's not me. That wasn't me," right?
Yep.
What other documentation? What other things could you do? What would you, and I mean, short of giving true advice here, that you charge for, what would you say that person should do?
Well, I mean, we just have to recognize something, which is that the inability to link a human being with a web entry is an existential crisis that the performance marketing and the lead generation and the folks that rely on lead and make phone calls and reliance, it is crippling to the entire business model because there is no magic bullet solution. It is wonderful and important that you have third-party lead verification, but what we are seeing now, and it's just too many cases to ignore. Our courts saying, I see all this evidence, but unless you can link that IP address to this consumer, and this consumer is swearing under oath, I did not go to that website, I did not provide my information. In one case, I was on a road trip to a zoo, so I couldn't possibly have done it at the date and time that this data entry says I did. The courts are saying that's a tribal issue. We're not going to enforce it. We're not going to enforce arbitration provisions. We're not going to enforce disclosures. You're going to go to the jury. And so time and time again now, these folks are being forced to try the case, right? You're going to put this guy on the stand, and you're going to have a trial lawyer, maybe me, maybe somebody else, cross-examine him. And the success or failure of that case, of the ability to uphold that arbitration provision, uphold that express consent provision, is going to turn on the credibility of a witness and the skill of the legal advocate in the courtroom. And that is not the way this is supposed to work, folks. You're supposed to be able to get this third-party verification, demonstrating precisely what language was on the website at the time of the interaction, proving that there was an interaction, and that's supposed to make this case go away. And there are still a number of plaintiffs' lawyers that will not continue to press a case in the face of one of these Jornaya reports or active prospect reports, but there are a number of others that, in my opinion, they're riding the line of ethics, because we all know that most of the time these guys are not telling the truth when they say, I never went to that website 4.5 years ago. Of course you did. Of course you forgot that you did. But, set that aside. These people are getting on the stand. They're testifying that they never went to that website, and the courts are accepting that testimony. And this is a real problem. I mean, it is a real serious problem. And the answer is ultimately going to lie with a petition to the FCC, an action from the FCC that gives callers a right to presume that data received over an authenticated web form submission is valid. And until somebody takes a crack at that petition, and until the FCC gives you that link, which is just really critically needed, we are at risk. I mean, the end, bottom line.
Yeah. Yeah, I know that's as good an answer as you can give with so much uncertainty with what's going on out there. I mean, I do think that, like, once again, and I hate to beat the drum, throwing other pieces of technology like ad fraud solutions to help weed out at least known traffic that we could identify that would help not making those calls. So, but thank you for that. Elliot, I'm gonna go back to you, and then Eric, I'm gonna end with you because we want to talk about the Supreme Court in the next 9-10 minutes as we get through this. But Elliot, there's been a lot of changes, as you mentioned. I think we're second, third revision of CCPA. Yep. And one of the things I do know is there are things that they keep throwing in there that you didn't really know from the beginning that were going to be thrown in there. And one of the things was like Americans with Disability Act. It found its way in there, and we've been putting that on the stage now for months, that people are starting to get sued just for ADA non-compliancy on their websites. And so, how does that tie back into CCPA and then other things that might have been just crammed into this thing?
Well, so the ability to bring a suit for not complying with the ADA when it comes to website accessibility has existed for a while, right? There's a whole cottage industry, and those are expensive suits to defend for one person. And, to be honest, I think the AG just came out of nowhere on that, of basically reading in the accessibility requirements into the statute. So that was a surprise to a lot of people. That these websites all must now be accessible, and it's a actionable violation of the CCPA to not do that. There were a lot of other surprises too, though, right? There's been a battle for 10, 15 years over do not track, and it ultimately resulted in the current law under CalOPA of just, you have to tell people whether you honor do not track. And that was kind of, everyone just sort of now in their website statement says, we don't, and that's all you have to do, really. But in the CCPA regulations, the AG seems to have snuck in a requirement that you treat user-enabled privacy controls as valid requests to opt out of the sale of data. And so that basically is an end run that makes, at least potentially, do not track mandatory for folks. And it just sort of blows my mind that we couldn't get consensus with the industry for so many years, and now they're just sort of sticking that stuff in there.
So as I want to end with you, Elliot, before we go back and talk about the Supreme Court, what should a company be doing today? Yeah. What are some of the easy 1, 2, 3s that they should be doing?
Yeah, so I understand full CCPA compliance can be a lot of work. I mean, the AG estimated that a small to medium-sized company should spend at least $75,000 on it, right? That's in the AG's report. Bigger companies are going to spend a lot more than that. But what you really, really, really need to do is focus on the things that are the most risky and the things that the AG is likely to target. So for sure, external facing issues. Get your privacy notice in order. The CCPA has extremely detailed requirements that just never existed before in the United States. It's way more specific than the GDPR in what you need to disclose, in particular with granularity, how you share data. For each type of data, the types of third parties you share it with for your business operations, and separately if you sell it. You have to put that do not sell button up if you sell. And in the industry, there is a wide range of opinions on what constitutes a sale. You have sort of Facebook at one end of the spectrum that seems to think that nothing's a sale, and then you have folks at the way other end of the spectrum, like the IAB, I think, that seems to think everything's a sale. So the answer is probably somewhere in the middle there, but think very carefully about it. Here's the thing. Data is very valuable, right? And the regulations are clear that if you don't have the do not sell button up, you can't sell data, right? And the CCPA regime is just an opt-out regime. A lot of people aren't going to exercise it. Putting out that notice makes your data much more valuable because then you can sell it. So I would say if you're in a close call, you probably should just do it. It's safer from a risk mitigation standpoint, but also it makes your data a lot more valuable because it's clean. So the external facing stuff. The other part is putting up notices of what rights people have and making sure to respond to requests for access or to delete or to opt out of the sale. That's something that's high priority for the AG. So make sure to do those things. If you happen to work with minors, you should be really careful to follow the rules on that. That's going to be top of the list too for the AG. Over the next 6 months, you should definitely get all the other pieces in your house in order behind the scenes to make sure you have the policies, procedures to support all these representations and requirements. But at a minimum, there's 3 or 4 things that I was just talking about that you should absolutely have done, because it'll be immediately obvious if you don't, and you'll be the low-hanging fruit. So that's my advice.
You just blew my mind. How do people reach out and get a hold of you if they want to get? They go to Squire Patton Boggs' website and then look up Elliot Golding. Is that the best way?
Yeah, that's a good way. You can email me, ELLIOT, so 2 L's 1 T, right. .Golding, GLDING at squirepb.com. But yeah, just send out my contact info. Happy to answer questions. I'm kind of a total dork about this CCPA stuff. I really get in the weeds, so happy to answer any questions people have.
Thank you. I wanted to make sure that you got all of your stuff in, because I'm going to move over to this other guy who I ask all the time, what's your opinion about something? And he does not hold his opinion back. And so I want to close this thing out, Eric. We missed a lot of things I'd love to have talked about. We'll have to do this again and break down some of the other elements. But in particular, something happened at the beginning of this year where the Supreme Court decided to do something. And I asked you on the stage just a few months ago in Orlando when we all got COVID and got home, what's your opinion? Is this thing going to be, what's going to happen to TCPA when the Supreme Court sees this?
All right, so we have to reorient ourselves and remember that there's a big split about what the definition of automated telephone dialing system is. The appeal to SCOTUS does not directly address ATDS. However, I believe SCOTUS is extremely likely to address that issue and in a way that will be very favorable for business. So backing up, the TCPA is and has been, since it was enacted, the single broadest restriction on constitutionally protected speech in our nation's history. And it's not even close. 99% of enactments that impact speech look at the content of speech and are extremely narrow. For instance, like you can't yell something specific like fire in a theater, and there's restrictions on pornography, and there's restrictions on false speech. All of that is considered to be non-constitutionally protected. But when you look at constitutionally protected speech, stuff like a business outreach to communicate with the consumer, just like a political outreach to communicate with a potential voter. This stuff is core political speech, core First Amendment protected speech, but all of that is covered by the TCPA in a way that, again, no other statute has ever even tried in our nation's history. It's very unique. It's incredible that the statute's been on the books as long as it has been. But up until 1995, it was treated as a content-neutral statute, which means that it was subject to a lower level of scrutiny under the Constitution. Frankly, it shouldn't even survive the lower level of scrutiny, in my opinion, and I think the Supreme Court might ultimately go there. But because the statute now is content-specific, it allows certain favored speech, certain speech that the government favors, and restricts speech of private speakers in a different way. Something called strict scrutiny is now being applied under the First Amendment principles. And strict scrutiny requires there to be a very, very compelling governmental interest underlying the statute, and that the statute be very narrowly tailored, that it impact no more speech than is absolutely necessary to accomplish that government interest, okay? That is now the standard that is going to be applied to the TCPA. Except there's something really tricky here. Most speech statutes will restrict speech. For instance, you cannot do X, you cannot do Y. The TCPA is written in a weird way where the exemption that is content specific is an exemption. It's not part of the restriction itself. So the restriction looks like it's content neutral, but the exemption makes it content specific. Now, I don't want to get too technical here, but essentially it's like if Congress passed a law that says you can't use Twitter to talk about socialism, well, that would be illegal because the restriction is content specific, right? Socialism is the content, and the restriction says you can't talk about socialism. What the TCPA does is trickier. It says, essentially, you can't use Twitter unless you're talking about something other than socialism. And that unless is leading the government to argue, well, if you just take out the part after unless, then the content specific issue gets taken out, and now the statute is constitutional again. Well, think about that. In the example I just gave, then the new statute would read, it's illegal to use Twitter, period. In other words, what the government is arguing is that you expand the reach of the statute to get rid of the content-specific problem. But when you do that, you're covering more speech than ever before. So the government is actually asking SCOTUS to make the TCPA broader and to get rid of protected speech to an even further degree. In my opinion, that's not going to happen. The government, by the way, is also arguing that it is allowed to exempt itself always from free speech laws, such that it can pass a law saying that the government alone is allowed to speak on a subject or in a certain way, and private speakers are not allowed to speak in that way, which, by the way, is the scariest thing that has ever been argued to the Supreme Court in the history of our nation, in my opinion, that the U.S. government is literally arguing that it can exempt itself from any speech restriction and prevent private speech on that topic or in that manner. That is nuts. And that is literally what is being argued right now by the government to the United States Supreme Court. And every American should be pissed about that. But I'm not the only one talking about it. So leave that alone. Bottom line is, what's going to happen? Well, in my opinion, what's going to occur is the SCOTUS is going to look at the statute. It's not going to do this phony baloney cross out the exemption thing that the Ninth Circuit and the Fourth Circuit have done. That's ridiculous that they would expand the statute. They're not going to find that the government can do whatever it wants and private speakers can be restricted while the government speaks. It's not going to do that either. That's preposterous. What the SCOTUS is going to do is exactly what it's supposed to do. It's going to protect free speech because it's going to apply the doctrines that have been in place for decades to the statute as it is written, and they're going to look at the statute and they're going to say, is this thing narrowly tailored to a compelling governmental interest, yes or no? Now, there's going to be a strong bend, as there always is, towards keeping the statute on the books. Nobody wants to throw out Congress's hard work. So they're going to try to interpret the statute in a way to make it constitutional. That's one of the doctrines that the Supreme Court uses when it looks at statutes. How can we interpret this in a way to keep it constitutional? And as it turns out with the TCPA, they can probably do it. How? They look at the ATDS definition and they say, if we read this narrowly so that it applies only to random or sequentially generated phone numbers, then we do have a very narrow enactment that is, in fact, tailored to a compelling governmental interest. That is, preventing random fire telemarketing or other calls that tie up 911 lines, that tie up business lines, that make it impossible for consumers to use their phones. That is a compelling interest. And so what the Supreme Court can, should, and I think will do is hold that strict scrutiny applies to the statute, but if you narrowly interpret the statute can survive strict scrutiny even with the content-specific exemption intact. And that's what's going to happen.
Whoa. So it will stay intact with the narrow scrutiny. And instead of what you said on the stage, you said at one point in time, TCPA is going to go away.
Well, that's the other alternative. I think that the most likely scenario is that they're going to try to interpret the statute in a way to save it. And so they're going to narrow it. Now, again, if you're narrowing the ATDS definition to only random fire dialers, you're essentially getting rid of it anyway. The other alternative, though, is, and I know I've got a big scholar, Squire Patton Boggs has this massive appellate team with like a bunch of clerks from the Supreme Court. And I did talk to one of our appellate guys, and he said, look, Eric, your analysis is dead on, except you go one step too far. The Supreme Court is not itself going to interpret the statute narrowly. It's going to send back to the Court of Appeal and ask it, you got your analysis wrong. You need to properly apply strict scrutiny to the statute, and then you decide what happens. So although the appellate gurus say I'm right, they think that that last step is going to happen at the appellate level, at the Court of Appeals level, not at the Supreme Court level. I don't think so. I think the Supreme Court's there. They're looking at it. They're just going to make the decision. But you're right. The statute could also just get struck down. The restriction could just get struck down flat, and the Supremes could send it back to Congress to rewrite it, which, by the way, may or may not be the best thing for everybody. But that option's out there as well.
Never a boring and or short answer from you, Eric Troutman. I really appreciate that. Listen, first of all, before I say goodbye and give everybody their wrap up, how can people get a hold of you also at Squire Patton Boggs' website and your email address?
No, man, tcpaworld.com.
tcpaworld.com. I did that for you just so you could promote it one more time. Does everybody get a hat or a mug if they write you? I'm not sure.
Yeah.
Okay.
I mean, we've got mugs, we've got hats, we've got T-shirts, we've got the old black one, the classic black as they're called. We also have a new like gray with like a blue. They're really nice.
Well, guys, I want to thank both of you for joining. The council can't do what it's doing without the help and volunteerism that you guys do. I really appreciate it. I really like to dive deep into this maybe somewhere shortly in the future. I know you're busy and you need to go. The council's here with the weekly webinar series every Thursday, 3 p.m. Eastern, 12 p.m. Pacific. Once again, if you go to LeadsCouncil.org, we do have on our membership tab our silver membership now from $2,000 down to $500 a year or $42 a month. There's absolutely no reason for you not to join. You get access to content like this all the time. And so once again, Elliot, thank you. Eric, thank you. I really appreciate your time. Let's have a good day.
Thanks very much.
Bye.